24 CR 2059 is called. You were Quincy Taylor,
Yes, sir.
Mr. Taylor, and you are charged here with an indictment alleging that you committed the second degree felony of aggravated assault with a deadly weapon. A second degree felony, if convicted, carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing?
Mhm.
Well, it doesn't end there, because the indictment also includes 2 prior convictions. One in June of 2007 for obstruction or retaliation, a third degree felony. And this states you were convicted out of the 361st District Court of Brazos County, Texas. After that conviction was final, paragraph 3 in this indictment states you committed the felony of aggravated assault with a deadly weapon, a second degree felony, and you were finally convicted of that crime in 2017 out of the 85th District Court of Brazos County, Texas. And now, after those 2 are completed, this alleges you committed this offense here in March of last year, a second degree felony. So, if all of this was true, found true, those prior convictions were true as they are alleged, and then if you're convicted of this, then this is what we call habitual felony status, which means you are looking at, if convicted, no less than 25 years in prison, up to 99 years confinement in prison, or life imprisonment, and and a fine up to $10,000 could be assessed. It doesn't end there. The allegation here in this indictment is that you committed this aggravated assault and with a deadly weapon, and the deadly weapon is alleged to have been a mug, I guess a coffee cup kind of thing.
Cool.
And that in the manner of its use and intended use was capable of causing serious bodily injury or death, as you intentionally, knowingly, or recklessly, it is alleged, caused bodily injury to the complainant by striking him in the head with the mug. And the way it is alleged, if this was found true, then whatever sentence you receive, you cannot be released from prison for parole until you serve at least 50% of the time. So if you were sentenced to 30, you'd have to serve 15 before you were released. So these are all serious allegations, and you have to be careful as you work your way through this one. Do you understand what you're facing? You have to speak out so I know.
I understand.
It's not good. It's bleak, but you're presumed innocent, and that's the way the law is, unless you're found guilty. Mr. West is here representing you. What are we going to do today?
Set the trial, Your Honor. We've talked about the case, and he's adamant that he's not guilty of this. So let's
All right.
set it on trial.
All right. When can y'all be ready? Again, this is another fast track. He's not gonna sit and languish. I want this done.
We can be ready next week, Your Honor. We have
in a few
video of it
weeks.
happening. So
All right, let's get this done. Y'all be ready? Get ready. Okay, we'll set it for trial. Thank you. Try to get that done now. Benjamin
Yes, Judge, I'm ready.
Figueroa?
Yes, Judge.
Oh, family well?
Oh, yes.
Yes. Burglary, 10 years to burglary. What are we gonna do?
Oh, Judge, today's we're asking for a bond. He's on deferred. He was arrested for a DWI. There's no bond set.
Hello. It's not all you're arrested for. They got three different crimes here, Les. You know that. Looks like all on August 9th. All right, we now call Benjamin Figueroa. That's you, Mr. Figueroa? 24 CR 807. You are here with your attorney and the state's attorney, Mr. Galmore.
Okay, I'm sure that.
Changing players
yes, sir.
in the middle of the game, huh? Okay.
Tag team, Judge.
It looks like illegal motion there. All right, you were placed on probation in this court apparently on October 24th of last year for burglary of a habitation, a second degree felony. Do you understand?
He's refusing.
Does he understand?
Yes, sir.
Okay, all right. Are you a legal resident of the United States? You're a citizen of the United States?
Yes, sir.
Okay, good. You were quiet, and that's okay. I just want to make sure you understand the seriousness of all of this. So you were placed on deferred or unadjudicated probation for the second-degree felony of burglary of a habitation, which carries with it up to 20 years in prison. So that's serious. Now, we got a motion to revoke probation that was filed in September, and it alleges that in August of this year, apparently you are alleged to have committed the offenses of operating a motor vehicle while intoxicated on August 9th of 2025 in Jefferson County, Texas, in violation of condition 1 of your probation order, committing the offense of evading arrest or detention on or about August 9th, 2025 in Jefferson County, Texas, in violation of your deferred or unadjudicated probation order, and committing the offense of disorderly conduct. Language, there's some cursing involved, I guess, on or about August 9th, 2025 in Jefferson County in violation of your probation. And then finally, it states you failed to provide verification of performing community service hours as required. And you've been on probation, let's see, going on a year. What about his community service from probation? Has he served any? None in a year? No. Okay, I have a public safety report that has been received. For the record. The court is bound to refer to this in a setting of a bond. And this is made part of the record here for the purposes of the bond hearing. And among other information, it looks like in 2012, the defendant was convicted of a misdemeanor of interference with public duties, whatever that is. Generically, I understand what it is. I'm not sure what exactly happened there. In 2023, in August, he was placed on this. This was the arrest date. He was then placed on probation by this court on October 24th of last year for burglary of a habitation. And then it looks like he was arrested in March of last year, which was before he was placed on probation in this court for driving while intoxicated. And as he was convicted, can you pull that up in the criminal history? It doesn't say where this happened. It says the arrest date was on 3/31/24. And then it says he was convicted, sentenced to 90 days probation, 15 months probation, sentenced to 90 days in custody, probated for 15 months. I guess then what we have here is now
That was out of County Court Law number 3, Your Honor.
when.
That was on February 26, 2025.
So that's his first one. And then now we have in August 9th, he gets a DWI, and that's why they're calling it the second one because of that one,
Yes,
that
sir.
earlier one, I guess.
Yes, sir.
And then also on August 9th of 25, he's charged with evading arrest. And August 9th, also charged with resisting. 2 of those are alleged in this motion to revoke probation. But also on this night, also he was alleged to have committed disorderly conduct language. I think that's a Class C misdemeanor. All right. So the public safety report has been reviewed. Look at the probable cause affidavit. Okay. The probable cause affidavit states here on August 9th, among other things, it states the police arrived at a location in Groves at about 6, a little after 6 in the evening, and found the defendant who was exiting his vehicle, a Chevy Silverado with keys still in the ignition, and he's holding a case of beer and then attempts to run away with the beer as the police are hollering verbal commands and allegedly physical resistance. The officers was arrested. On speaking with Brewer, he advised that the defendant allegedly did not speak to the lady in a real orderly fashion and was very rude and abusive and vulgar. And he was arrested for DWI and attempting to evade police. It's always hard to evade police and run away when you're carrying a case of beer. That's always what I've heard. Tends to slow you down. What was the result of the specimen that was drawn? Do we know?
Let me check, Your Honor. It's a miss. No, it's above 0.15, but let me get the.
You live alone, sir?
Yes.
You live alone? You don't have a wife
No.
or companion,
Yeah, I do have a company.
sir?
I do have a company.
Does that person drive?
Yes,
Do they have a driver's license?
yes.
0.191, Your Honor.
A little high, over twice the legal limit. But no drugs.
No, Your Honor. I don't think it was tested.
What are you asking?
I don't think it was tested.
Judge, we're just asking the court to set a bond. We would ask the court to set the bond at a lower amount, maybe 5 or 10,000, just so that he can afford the alcohol detection device that he's currently got installed in his vehicle.
All right, anything else?
Your Honor, I would just ask that it, be somewhere around $50,000. Defendant each time has, he gets intoxicated. That's what the burglary arose out of. That's what there was another evading before that got dismissed in consideration for the burglary. There was both these DWIs. It's all arising out of him consuming alcohol and one way or another, either being very reckless with that.
Here's what we're gonna do. It'll save him some money, a little bit, of what my master plan is, but it's gonna reduce his freedom. Sir, your bond is gonna be $20,000. You must stay in home confinement. You cannot leave the home except for work, food, medical needs, and you must take the most direct route to and from those locations. You're not going to drive a car or a vehicle. The companion who is going to have to help you drive. I don't want you behind the wheel of a car. Do you understand? Until I order otherwise. And it would be catastrophic. And if you have to drive I was going to say interlock device, but what's the point? You're ordered not to drive a car. So we don't need to get to that second step. And there will be other conditions of bond. We don't commit another crime and come to all the court settings. Is there any other additional terms and conditions we ought to set? Because, this is.
Your Honor, would ask that he abide by the SCRAM program or have that ordered, that he wear the SCRAM device. That way he, should he not adhere to the court's order of him driving, that we have some second measure there to kind of keep an eye on that, make sure he's not consuming alcohol and getting out there on the road or endangering others.
What good would that do? That's not being, he has significant penalties if I catch him. If he's on a SCRAM device, it's going to have the same ramification. It wouldn't deter any misconduct, that it would deter his future and his freedom to an extraordinary degree. I think you understand how serious this court's treating it. I guess I could load you up with all kinds of contraceptive devices here to prevent you from driving a car, but if you wanted to drive one, there's nothing I can do about it. It's just, if you're caught, shame on you. I would not be lenient. Here's what we are going to do. Everybody get ready fast. Let's get this motion done. This can't be that hard. Let's get it. When can y'all be ready? 4 weeks?
I'm sure that would be sufficient.
Good. All right, let's do it then. And then we'll see what happens next. Okay, thank you.